And my lord, that rule envisages an application for stay of execution pending an appeal. That rule, my lord, at sub-rule 2 envisages the application being made informally. The rule provides that such an application for stay of execution may be made informally immediately following the delivery of the judgment or ruling to the court, and the court may issue such orders as it deems fit.
You said Rule 32?
Rule 32, 1 and 2 of the Lutunga Rule.
Yes, Rule 32.
Yes.
Yeah.
My lord, the first and second respondents have wished to appeal the decision that you have made this morning to the Court of Appeal, as they are entitled to do. But my lord, in seeking to persuade you or in considering an application for stay of execution, the court is enjoined to take into consideration two issues. First of all, is the intended appeal arguable? And will the appeal then be rendered nugatory if the stay that is sought is not granted? Well, one of the main findings that you have made in this matter is on the issue of the court's ability to determine ex parte with finality an application for conservative orders. My lord, there is a decision of the Court of Appeal, and that is one of the grounds that the appellant or the first and second respondents wish to take on appeal. There is a decision of the Court of Appeal, my lord, that speaks to that point, but it speaks differently from what your lordship has found. And my lord, I wish to refer you to the decision of the Court of Appeal in Civil Appeal number E984. E984 of 2024. The parties are the Cabinet Secretary, Ministry of Health, who was the appellant, and Joseph Enoch Aura, and 12 others. Well, this decision of the Court of Appeal considered the point which I have just highlighted and the point that you determined. And the Court of Appeal makes an instructive finding at paragraph 57. Paragraph 57, commencing the second sentence, commenting on the High Court's ability to issue ex parte conservatory orders. It says, it is in essence that we perceive ex parte orders to be exceptional, and orders which ought to be issued for a very limited period, pending the hearing and determination of all affected parties. It is noteworthy that the law does not contemplate a permanent ex parte injunction. An ex parte injunction can only be temporary for a limited period and may only be confirmed after the hearing of the party against whom it has been issued.
I've heard you on this application. All the respondents except the team of Mr. Achot has supported the application. The issue is whether I should stay the orders issued on 8th of January and reinforced on 13th. The court issued an order that the petitioners be released or their bodies will present it to court. Today, the court has just dismissed an application to set aside those orders. Granting the application would amount to setting aside the orders, because today the court has just returned a negative order. For that reason, I decline the invitation to set aside the orders. Thank you.
My Lord, moving to the orders that you issued, that I would belabor the court if I was to date. However, I will. On the 8th, you reaffirmed them on the 13th.
So, Mr. Nyamodi, when should your client come to court? Even as you pursue your rights to appeal.
I leave that to court.
You leave it to court?
I leave that to court, but I would then ask that perhaps you consider 7 days.
Where is he next week?
Can I ask his officers who are with me, my lord?
Just don't ask, because you said you need 7 days.
My lord, I am informed by my client's officers in court that next week he is out of the country, perhaps the following week.
I will not go that way, Mr. Nyamodi. Out of the country where?
My Lord, if I may.
Yes. Let me make my own orders. Let me make my own orders. Confirm compliance with the orders of the court, and if not, why not?
My lord, I'm most obliged. May I request that I be supplied with your decision of today and the certified copies in the proceeding in this file as well.
Excuse me.